Welcome back to the Deep Dive. Today, we're getting into the absolute bedrock of American law. We're talking about the legal architecture that really built the United States. Because if you think the Constitution answered all the questions about power, who has it, the feds or the states, well, it didn't. Not really.
Not at all. Those boundaries were actually hammered out in a series of really high-stakes, explosive court battles in the early 1800s.
Exactly.
And our sources today, they're all focused reviews on 5 of these foundational Supreme Court cases. What we want you to see is that these aren't just like dusty historical footnotes.
Right.
These are the moments where the checks and balances and really the boundaries between Washington, D.C. and the state capitals were decided.
Our mission is pretty simple. We want to synthesize the key facts, the huge rulings, and the lasting impact of these 5 pillars. They didn't just create our modern government structure.
No, they also contain these deep fundamental conflicts, especially over things like slavery and states' rights.
And those conflicts led the nation straight into its biggest crises. So this is your shortcut to really understanding the legal DNA of the American system.
Yeah, that's a great way to put it.
Okay, so let's unpack this. We have to start where the Supreme Court really claimed its status as an equal branch of government.
The famous one, Marbury v. Madison, 1803.
That's the one.
What's so fascinating about Marbury is that the court's biggest jump in power, it actually came from a decision where they technically lost the immediate fight.
Right, it's a political masterstroke.
It is. So it's 1803, and the whole thing starts with this political mess called the Midnight Judges. William Marbury was one of these guys. He'd been appointed a judge right at the end of President Adams's term, but his official paperwork, his commission...
It just never got delivered.
It never got delivered by the new Secretary of State, James Madison.
So Marbury sues. He wants the Supreme Court to issue what's called a writ of mandamus.
Which is basically a court order.
Yeah, an order forcing Madison to hand over the paperwork so he can get the job he was legally promised.
And this puts Chief Justice John Marshall in an absolutely impossible spot politically.
A total bind.
A total bind. If he orders Madison to deliver the commission, President Jefferson's administration will almost certainly just ignore him.
Which makes the court look completely powerless.
Exactly. But if he sides with Jefferson, the court looks weak, like it's just doing whatever the president wants.
So Marshall does something, well, brilliant. It's deeply political. He gives up the small Win Marbury's job to seize this massive, permanent power for the court.
That's the whole game right there. The court rules against Marbury, but not because Marbury was wrong on the facts.
No.
They say that the part of the law, the Judiciary Act of 1789, that gave them the power to issue that kind of order in the first place was actually unconstitutional.
So they're striking down a law passed by Congress.
Yes. And this is the monumental takeaway for you. By declaring a piece of federal law unconstitutional, Marshall establishes judicial review.
A principle that isn't even written in the Constitution itself.
Not explicitly, no. But it gives the Supreme Court the final authority to interpret the Constitution and strike down any federal law that conflicts with it.
It's a huge power grab.
It immediately and dramatically increases the power of the federal government, specifically the judicial branch. It means the Supreme Court is the final umpire on what the law is, full stop.
It's the ultimate check on the other 2 branches.
The ultimate check.
Okay, so if Marbury established the court's power over laws, our next 2 cases are all about the federal government's power over the states and the economy.
Right. Now we move to McCulloch v. Maryland in 1819, a direct fight over federal supremacy.
And this one is about a bank.
It's a test of sovereignty, really. Maryland, like a lot of other states, was totally against the federal government running a national bank inside its borders. They saw it as a massive overreach.
So they try to kill it.
They try to tax it to death. They put this heavy state tax on the Bank of the United States. And James McCulloch, who was the cashier at the Baltimore branch, just flat out refused to pay.
So he draws a line in the sand.
A clear line. Can the federal government create a bank? And can a state government tax a federal operation?
And the Supreme Court comes back with this huge 2-part answer.
A massive victory for federal power. First, they rule that states cannot tax the federal government, period.
Because, as Marshall wrote, the power to tax is the power to destroy.
Exactly. If a state could tax a federal entity, it could basically veto any federal project it didn't like.
But the second part is, in some ways, even bigger. The court confirms that Congress can create a national bank, even though the Constitution doesn't explicitly say you can create a bank.
And this is where we get the necessary and proper clause, the elastic clause, really flexing its muscle.
Explain that.
Marshall's ruling argues that since the Constitution gives Congress powers like taxing and borrowing money, well, creating a bank is a necessary and proper way to carry out those powers.
So it implies powers that aren't spelled out.
It gives Congress implied powers. It meant federal power wasn't just limited to the list in the Constitution. It could expand to cover anything reasonably connected to its duties.
And if you're watching this in 1819, that's a little terrifying.
It's terrifying. The central government's reach just grew exponentially.
Okay, so that's finance. What about trade?
That brings us to the next case, Gibbons v. Ogden in 1824. This one defined federal control over commerce.
And this is a fight over steamboats, of all things.
Sounds kind of mundane, but it was a huge deal. You had one guy, Ogden, with a monopoly license from New York to run ferries on the Hudson River.
And the other guy, Gibbons, has a competing license, but his is from the federal government.
So the question is, who controls the water route between New York and New Jersey? The state or the federal government?
And the court has to settle it.
They do. They rule that under the Interstate Commerce Clause in the Constitution, Congress controls all trade between states. The federal license wins.
The state monopoly is toast.
It's gone. And if you connect this to the big picture, this ruling gives Congress almost limitless power to regulate the national economy.
And this is why you should care, right? This seemingly small decision about steamboats.
It's the foundation.
It is the foundation for how the federal government today regulates everything from pipelines and airlines to, trucking and almost all economic activity that crosses state lines.
It confirmed Washington was supreme in finance, taxation, and now commerce.
All right, so we've seen the court establish its own power with Marbury, and then use that power to expand federal authority over the states with McCulloch and Gibbons. But now we have to turn to the cases that showed the cracks in the system.
This is where it gets really interesting and, frankly, tragic. We're at Worcester v. Georgia, 1832.
So what's the situation here?
The state of Georgia was trying to seize land from the Cherokee Nation, basically forcing them off their own territory.
And a missionary, Samuel Worcester, challenges this.
He and others argue that Georgia has no legal authority inside Cherokee territory. The tribes had treaties with the federal government, not the Starts.
So it's another federal versus state power struggle.
Yes, and the Supreme Court, again led by Marshall, sides decisively with the Cherokee Nation. The ruling states that the Cherokee Nation is a distinct political community, meaning only the federal government can deal with them. The states can't interfere. It was a very powerful legal statement.
Powerful legal statement, yes.
Yeah.
But here's the twist, the real-world fallout.
This is the moment. President Andrew Jackson, he just ignores the ruling.
He's reported to have said something like, John Marshall has made his decision, now let him enforce it.
That's the quote. And it raises this huge question about the limits of the court's power. Jackson refused to use federal force to protect the Cherokee.
And that defiance led directly to the forced removal we all know as the Trail of Tears.
A horrific tragedy. It proved that judicial review, for all its legal weight, really depends on the political cooperation of the other branches to mean anything in reality.
But wait, so if Jackson could just ignore the court, does that make the power from Marbury worthless?
Not worthless, but conditional. The court has the power of persuasion, not the power of enforcement. If the executive branch is willing to take the political heat for defying the court, which Jackson was, the ruling becomes, just words on paper.
That's a sobering thought.
It highlights the fragility of the whole system.
And that tension brings us to what might be the single most catastrophic decision in Supreme Court history. A case that didn't just expose tensions, but blew them wide open.
Dred Scott v. Samford, 1857. The stakes just could not have been higher.
What was Dred Scott's argument?
He was an enslaved man who had lived with his owner in free states and territories. So he sued for his freedom, arguing that living on free soil should have made him free.
A simple enough argument, it seems.
You'd think so. Chief Justice Roger Taney, however, used the case to try and permanently settle the slavery debate in favor of the South. Instead, he drove the nation right off a cliff.
What did the ruling actually say?
It was devastating. It had two main, just morally bankrupt parts. First, the court ruled that African Americans, whether they were enslaved or free, were not citizens.
Not citizens at all.
And could never be citizens. And therefore, they had no right to sue in federal court in the first place.
The implication there is just shocking. that an entire race of people had no rights.
It was shocking even then, but the second part was maybe even more politically explosive. The court also declared that Congress has no power to ban slavery in the federal territories. And in doing that, it strikes down the Missouri Compromise of 1820.
The main legislative deal that had kept a fragile peace for decades.
Gone in an instant. The fallout was immediate. It was this huge victory for slaveholders. It said that enslaved people were just property, and that property was protected by the Constitution.
So, connecting the dots here.
Yeah.
The ruling basically destroyed any hope of a political compromise on slavery.
It shattered it. It showed the court was willing to actively side with the slaveholding states and expand slavery. It just erased any middle ground and pushed the North and South directly towards the Civil War.
That was a tremendous journey through the legal foundations. 5 pillars that defined federal power through conflict.
A lot of conflict. We saw the court claim its own power in Marbury. Then we saw it empower Congress with the Elastic Clause in McCulloch and the Commerce Clause in Gibbons.
Establishing federal supremacy in finance and trade.
Right. And then we saw the whole system fracture.
We saw the limits of the court when the president just ignored it in Worcester. And we saw the court itself drive the nation into war with the awful decision in Dred Scott.
And these cases, they really show you the tension that's just built into the federal system. These definitions of power weren't handed down from on high. They were fought over, violently contested.
Shaped by politics, economics, and moral failure.
And they created the framework for pretty much every constitutional battle we still have today.
So, think about this as you go forward. The American system creates this incredible check on power judicial review back in 1803. The court can strike down any law.
A massive power.
But then, just a few decades later, in 1832, we learn that the power of that ruling depends entirely on political will. What good is a powerful, legally sound judgment if the person in charge just decides to ignore it? That deep tension between judicial authority and political reality, it's not just some historical footnote. It is a fundamental challenge that still shapes our legal and political landscape right now, today.